What is a registered pledge over shares in a limited liability company and how is this security enforced? These questions will be answered in a moment by Mateusz Tusznio, an advocate and restructuring advisor specializing in banking and finance law, as well as in restructuring corporate debt. Afterwards, I'll shine a spotlight on how Polish entrepreneurs currently view the zloty's replacement by the euro.
This is News from Poland Business and Law, program intended for foreigners acting as board members in Polish companies, foreign investors in Poland and their foreign advisors. Let's get started. In this episode, I would like to talk about out-of-court enforcement proceedings with reference to one of the most popular kind of the Polish security interest, registered pledge over shares in a limited liability company. A registered pledge is a standard Polish law security interest required by Polish lenders to secure their claims. It is registered in the Polish Public Register. Besides a security over assets, its professional lender also requires a security over shares, since the lender must have the option of taking control over the relevant debtor upon the occurrence of any event of default in the financing agreement. Poland offers many advantages in that regard compared with many other EU jurisdictions. Security over shares may be enforced using out-of-court enforcement methods, including the pledgee seizing title to the shares. Therefore, it is not usually necessary to instigate formal court enforcement proceedings to enforce a pledge over shares. Of course, as in any jurisdiction, insolvency and restructuring laws, as well as prior instigation of formal enforcement proceedings by another creditor, may affect the pledgee's rights in enforcement. Nevertheless, the out-of-court enforcement procedure is simple and straightforward. Foreign lenders must consider one important thing. Under Polish law, seizing title means taking control and ownership over the company, not temporary control. So, once the pledgee has seized the pledged shares, it is owner of the company with all the resulting legal and economic consequences. Temporary control may be attained without taking ownership by using a voting rights power of attorney, which is also market standard in Poland, and it is part of the pledge over shares. However, the debtor may easily challenge this legal instrument. The following steps should be taken on a seizure of title to the pledged shares: delivery of an enforcement notice to the pledgor, valuation, foreclosure notice, and sale of the foreclosed shares. Enforcement requires the enforcement notice to be sent and received by the pledgor. In practice, the delivery of the enforcement notice should be carried out with due care and attention. For example, in line with the notification clause contained in the security documents. We recommend sending this by recorded delivery letter as provided for by the Polish Post Office. The enforcement procedure can take place once the pledgor receives the enforcement notice. The next step is the valuation. The value of the pledged assets for the purpose of foreclosure is agreed upon by the parties in the pledge agreement. The terms of such sale must be based on their market value. In my opinion, the most effective and safe valuation method is one prepared by a professional appraiser. However, share pledge agreements may also provide some alternative valuations, not requiring the involvement of a professional appraiser. Those valuations are potentially legally more questionable than the professional valuation prepared by the appraiser. Once the pledged shares have been valued, the pledgor will be served with a foreclosure notice, a notice on taking over title to the pledged shares. Title is taken over at a price equaling the valuation of the shares. This means that upon serving the foreclosure notice, the secured claim, the outstanding financing claim, is decreased by the value of the foreclosed shares. A creditor who acquires the pledged shares can sell them to satisfy its claims from the proceeds. A further sale should be carried out in compliance with the provisions of the pledge agreement. However, there are no statutory provisions as regards the mechanism of such sale. Upon taking control over the company, the pledgee must take certain corporate actions. First of all, the pledgee must change the current management board and the registered office of the company and register such amendments with the Polish Corporate Register. In some cases, the pledgee must also obtain the consent of the President of the Competition and Consumer Protection Office for taking control over the company. Polish law requires also submitting notification about the ultimate beneficial owner. Last but not least, the new board members appointed by the pledgee should also obtain the current accounting documentation and obtain access to the company's bank accounts, which may be a time-consuming and formal process.
Of the 27 member states of the European Union, already 20 of them have a common currency, the euro. Poland is outside this monetary union. Our currency is still the zloty. Supporters of retaining the national currency argue that it is better to retain one's own monetary policy because it helps in overcoming economic crisis and increasing the economy's competitiveness, if only by deliberately weakening one's own currency. This leads to buyers seeing a cheapening of exported products and services, which consequently leads to an increase in the volume of Polish exports. They say that the euro is good, but only for countries with strong economies, such as Germany or Austria. It will only become cost-effective for Poland when we catch up with Germany in terms of GDP per capita and labor productivity. Nonetheless, at present, most of Poland's leading economists and heads of large and medium-sized companies, as well as the largest business organizations, favor the euro's adoption as soon as possible, once monetary union requirements have been met. This is due to a number of reasons. Firstly, adoption of the euro will eliminate exchange rate risks in trade with most EU countries, the destination of 75% of Polish exports. Large fluctuations in the zloty's exchange rate against the euro and the dollar have recently greatly complicated firms' business calculations and trade predictability. This increases the costs of financing their operations. Secondly, most products that are manufactured in Poland contain imported components. The weaker the zloty, the more expensive are the imports of these components. This offsets the benefits of having a weaker own currency. Finally, there is the political argument. The conviction that adoption of the euro will protect Poland from leaving the European Union, since its population would probably be reluctant to return to its own, much less trusted currency. Thank you for watching this episode. See you next time.